All right, we're going to go ahead and get started here. It looks like we've got a few attendees rolling in. Give a few more minutes for people to come in here, but we'll go ahead and get started. Today we've got Catharine Morisset, who's on the board for the Washington Hospitality Association, also a member of our advisory network and our editorial committee. So you are very involved in hospitality, Catharine. We very much appreciate it. I know our members do. Catherine, why don't you go ahead and tell us a little bit about yourself and then go ahead and start into the slides.
Hi, everyone. If you haven't met me yet, I am a partner with the law firm of Fisher Phillips. I work out of our Seattle office. We're a national law firm that represents only employers in labor and employment. I'm also a member of our firm's hospitality group, so I guess I am working with a lot of you all the time, which I really enjoy. My fun fact is I was actually a hotel concierge before I went to law school. So while I haven't waited tables, I have worked retail at Christmas. I'm not really sure if that counts, but I've worked in the hotel industry myself. And also I'm very sympathetic to employers trying to do the right thing. I litigate in state and federal court. I go to trial, I appear before state agencies, but I also like to work with a lot of preventative medicine. So my favorite place is to get to know folks like this and help with compliance issues before the bad thing happens so that we all can hopefully take care of our employees and our workforce and then move forward without having to deal with potential legal fallout. So I have a lot to share with you today. I'm going to go ahead and start sharing my screen so that we can jump in. I think the one thing I should say logistically speaking is please feel free to use the Q&A button or the chat today for questions. I'm going to try to monitor those as we go, but I've got Lex here to help me out. I'll try to pause from time to time. If I don't pause, Lex will just interrupt me and let me know we have a question. And I should have time for some questions at the end. We have a lot of dense things, so hang on a little bit. If I'm not quite getting to your FAQ, sometimes it'll show up in a later slide. So there might be a reason that I don't answer your question right away. So with that, I think the presentation should be up. Okay, I am talking about top Q&As for COVID. These change every week or every month or almost every day. When Lex and I planned this presentation, we actually said we would title what we titled it, but we didn't know what I was going to talk about yet because we wanted to see what developments we had. And sure enough, we've had some new proclamations from the governor of the state of Washington, some lack of movement on the federal level that I hoped I'd be able to talk to you about, and also a lot of updates from the Center for Disease Control. So one of the large groups of the FAQs today are quarantine and testing or return to work guidelines for employees who are sick, have been exposed, or might have been exposed. The CDC has overhauled those guidelines completely, and we're going to walk through those today. Whether employees have protected leave rights in our states is one of the most challenging areas for HR professionals and lawyers too. I have to look things up all the time when I'm talking to clients. So unfortunately now it feels like we all have to be lawyers, and even the lawyers are having a hard time figuring it out. So we're going to go through what leaves are available when folks have to self-quarantine, isolate, or we have them stay home from work. The governor also extended the high-risk worker rules, if everybody remembers those. That's folks who fall within certain medical categories or they're over the age of 65, and they're entitled to some additional protections during the pandemic. When the governor extended this rule, he actually gave us a new guidance and changed some things, so we're going to talk about that too. And even though this isn't an employee issue, I think guests who refuse to wear masks is an employee issue because we have a duty to take care of our employees and ensure they are safe from harm. So I'm going to talk about that just a little bit and give you some reference materials. The association and I picked these things out because this is where we're seeing the most questions. Of course, if we have time at the end and you want to hit me with something else, I'm more than happy to give it a stab. Okay, self-quarantine and isolation. What are those rules, says Lex. They were updated on July 22nd, 2020. This is one of the reasons why I give links in my presentation so you can write them down and hopefully have them bookmarked, because even if you think you know the rules might have changed and you need to check back. I'm gonna take a sip of my coffee here. I promise it's coffee. Okay, so the biggest change is that the CDC is discouraging any test-based procedures or strategies for deciding when employees can come back to work. That's a pretty big change. Before, they had asymptomatic versus asymptomatic tracks. Those were two branches. And then below that, they had if somebody tests or doesn't test, or if somebody tests and doesn't test. So we're going to talk through that. I've given you the landing page for the CDC here. My firm also wrote an article about it, so I've given you a link to that too. What are the rules, you might ask, if your county or the state of Washington has any different? Well, so far our state has continually tracked what the CDC recommends. So believe it or not, for example, King County got on this new guideline pretty quickly and updated its return to work guidelines, including they have a special pull down menu for food service workers. If you don't have that bookmarked, that's a good one to have. I kind of like the Q&As there. It's sort of user friendly. The Washington State Department of Health also has updated what you do if somebody is exposed and they're an employee of yours as well. And I've given you that landing page, although I'm going to point out that because it's a PDF, you might need to go back to the page if this happens to you, unfortunately, to ensure that you've got the most up-to-date things. I'm sure Lex can nod his head. Sometimes everybody isn't so good about extinguishing old links as the association is, so you want to be careful to go through the landing page.
Catherine, if I could add something, we'll make the slides available to folks after the presentation. Is that okay?
Absolutely.
I've gotten a couple queries about the links, so don't worry about tracking the links. We'll make those available to you afterwards. Thank you.
Or trying to write everything down, I should have said. Yeah, thanks, Lex. And by the way, I don't turn them into hyperlinks. I want you to see what the landing page is. So I know it's a lot of globbity-glook, but I think it's important to know what website I'm directing you to. Okay, let's start with the sad, unfortunate situation where we have an employee who's been diagnosed or is exposed. Now, this category isn't folks who we think might be exposed because they travel or could be exposed because of some other things they've told us. I'm talking about folks who say, my husband just was diagnosed with COVID. My sister was diagnosed with COVID and I was at a barbecue over her house. So this is the narrower category where we have an actual diagnosis and an actual case of exposure. So one of the questions that I get and have been getting from the beginning of the pandemic is, can I require a negative COVID-19 test before somebody comes back to work? And the CDC is now saying they strongly discourage following that model and to use a symptom-based strategy. Now, does that mean that you legally can require it? Probably. Hold on to your hats. I'll get to that in a second. But the CDC and our health departments are telling us that testing is strongly discouraged, requiring it before somebody can come back to work. Now, we have a state where testing, I don't know if you all have had to deal with this yet, but it's been about 2 to 3 days, so it's actually not that long. We're lucky that most folks seem to be able to get a test now. But again, the CDC is looking at this nationally and thinking about the drain on our healthcare system. Now, there's an exception for somebody who's severely immunocompromised. I mean, we want people like that to be going to the doctor anyway. I know it feels like we all have to be doctors now, but when in doubt, we are always going to refer our employees to their healthcare provider. In fact, the one caveat that I'm going to give to all of these slides is that what the employee's healthcare provider says trumps anything else. If their healthcare provider is recommending that they stay home 7 days, then that's what we're going to do. If they've got a health department maybe giving an order about folks needing to quarantine, like heaven forbid, if you've got a large outbreak at your workplace, those kinds of things are going to overrule the CDC guidelines. Oh, and then I had a note on here, sorry, this is a repeat, but it was for myself, that there's some provisions of the Families First Coronavirus Act that encourage us to maybe get doctor's notes. So put a footnote in that. We're going to talk about leave in a second. All right, what are those symptom-based guidelines that the CDC has come out with now? They've changed. I'm going to tell you what's changed, but what's on the slide are the new ones. They call it a milestone test. So the first one, if the employee's symptoms included a fever, if the employee stops taking aspirin or ibuprofen or anything else to reduce their fever, and it's been 24 hours since they had a fever, they've cleared that first milestone. It used to be 72 hours, so the CDC has actually reduced this. This might mean people are coming back to work sooner. That's kind of exciting. And then they want you to see that the symptoms are improving. It used to just be respiratory symptoms, but as we've all maybe learned by now, the CDC particularly, there's lots of other symptoms for COVID-19. So we're talking about all symptoms improving. And then the biggest change here is the CDC has decided, as a matter of course, most folks aren't contagious anymore after 10 days. And so the third milestone is if it's been 10 days since symptoms first began, the employee is going to be cleared to come back to work. So you could follow these three things and not require the doctor's note, according to CDC guidelines. There is an exception if somebody becomes severely ill with COVID-19. They're suggesting 20 days. I gotta tell you, you probably are never going to have to figure out this 20-day thing. If somebody's that ill with COVID, they're seeking medical care, and what you're going to get is a doctor's clearance for that person to return to work. What leave exists? So this is an employee who's been diagnosed with COVID, or somebody who we feel confident has been exposed to COVID, and we are sending them home to await diagnosis. Here's the leaves we talk about in our great state. We have the Families First Coronavirus Response Act, which should be FCRA. I've got my R and C transposed, sorry about that. We have Washington or Seattle, if you happen to be in Seattle's paid sick leave rights. And then don't forget about regular FMLA or regular Washington paid family medical leave. I have those here because they're going to apply if somebody becomes really ill. But so we're talking about somebody who actually has COVID and is going to be out for more than 3 or more days. I'm not going to go over those in detail. I'm going to talk more about how these first two have changed. Remember that the Families First Coronavirus Response Act says employees have this 2 weeks of paid leave available to them, or it's basically 2 weeks worth of their hours. We'll talk about that in a second. If they're subject to a federal, state, or local quarantine or isolation order. Also, number 2 on here is advised by a healthcare provider to self-quarantine. So what does this mean if we are directing an employee to stay home based on a conclusion we've made? Well, it's not clear if the Families First Coronavirus Act actually applies here. And here's why I say that based on the next couple of slides. So remember I said a few slides ago that while the CDC is strongly discouraging that somebody gets a test or goes and sees their healthcare provider, in order for somebody to qualify for this FCRA leave, we need them to have a healthcare provider recommending the quarantine. So this is where with a lot of my clients I end up with, we follow the CDC guidelines, but we still encourage our employees to go get a test or see their doctor. First off, we want to be doing that because we're not medical providers to our employees. And second off, we're trying to help our employees qualify for this leave. Because remember, you can always give this leave if you want to, but you might not get the tax credit. So here's the gotcha in this law. The FAQs, if you haven't had time to read them, are really, really helpful, but they're about up to FAQ 94 for FCRA now. But I pulled out just a couple. This one says, when am I eligible for paid sick leave to self-quarantine? And you'll see that the answer is you are eligible if a healthcare provider directs or advises you to stay home. So it's not because my employer told me to stay home because they're worried about me exposing others. It's because the healthcare provider has directed it. So there is a reason to send your employees still to see their doctor. The next one here we're talking about where emergency paid sick leave under the federal law could be available. And remember, this law applies only if you have under 500 employees or more than 50. It even says, I'm an employee, I become ill with symptoms, and I decide to stay home for 2 weeks. Well, good for this employee. I think this is a great thing that they don't want to take the risk of exposing folks. But they don't seek medical diagnosis or healthcare provider advice. Do they get the paid sick leave? And the federal government is telling us no, they wouldn't qualify under the Family First leave in this instance. So again, to qualify for this federal leave, it really encourages that employee seeking advice of a healthcare provider. Now, practically speaking, do I think this is going to be a big deal? My clients who have had to deal with this that I've talked to about have said that their employees have been able to have an appointment through telehealth or some sort of phone conversation with their office and with the doctor's office and gotten confirmation that they should quarantine. So it's been fairly easy in our state, at least. I'm curious if other folks have had a problem. I think it's changed maybe a couple months ago to at least get something here so that FCRA leave is optional, available. This is, you can look at when you get the slides back. I thought I'd just remind everybody how much leave is available. Now, when we talk about our state leaves, though, the analysis is completely different. So under our state and city laws, your paid sick leave, Washington State paid sick leave or Seattle paid sick leave, is available to you if your employer is directing you to stay home, or that slide that we just had about the I've become ill and I'm going to stay out for 2 weeks. So this absolutely must be available to your employees. Just a difference there. So when in doubt, the Washington State paid sick leave, if somebody has it available, is going to be available more readily than the FCRA leave. Now, this brings me to some common pitfalls. The biggest thing I think that I see employers getting wrong are these first 3 bullets. The first one is when the employee is symptomatic, or you learn the employee might be ill, or even if you're doing some screening, you forget to talk to your employees about what leave might be available. I know most folks are good about it 99% of the time. I tend to deal with the 1%. The other thing is that you cannot require employees to take FCRA, to take the emergency paid sick leave under federal law, or Washington State paid sick leave. I know that we want to encourage use of the federal emergency paid sick leave because we can get the tax credit, but even if the employee is eligible for the FCRA, they have the choice to use their Washington State paid sick leave first. That's always the choice. And by the way, if the employee wants to take the 14 days off and not get paid, that's their choice too. The other mistakes I see here are where employers are promising things that they're really not in a position to promise. And the biggest one is unemployment. I know we want to help our employees understand what unemployment benefits may be available to them, but in the end, the agency that decides if the employee is going to get unemployment is ESD, is the Employment Securities Department. So if we get stuck promising somebody they're going to get unemployment benefits and they don't qualify, you can be stuck paying for their leave. So that's really why you want to be cautious about not promising it. Also, of course, employees can't double dip. And sadly, I've already seen fraud. I've already seen where employees are trying to get both PTO and unemployment at the same time. And my gosh, the state's busy enough trying to catch that. I hope that you don't have to do that too. But that's an instance where the fact that you didn't mislead your employee into thinking that they were owed unemployment is going to save you. Because if it turns out the employee didn't qualify and they owe the money back to the state, and you as an employer told them something wrong, then think about how you could be stuck on the hook for that. So that's why I want you to be worried about that. The next thing is just to be sure that you're following the leave tracking rules. There is guidance in all of those long Department of Labor guidelines about what records you have to have in order to qualify for the tax credit. We think, I don't know if the IRS is going to change its rules tomorrow, but that is something that I see folks kind of, at the beginning, we were just giving people leave and then figuring you worry about it later. There's some paperwork you're going to have to get those tax credits. All right, I'll go ahead.
Catherine, I've got a question from Victoria. Does the employee have to initiate the conversation of paid leave, or do we as employer have to start the conversation? As a company, we have all leave options posted on employee communication boards and in our COVID-19 handbook.
Yeah, so for state and city law particularly, the burden's going to fall onto the employer to make sure that the employee knows they have that leave available. So it's great that we've got a policy and we've met all those notice requirements, but I've had many investigations by the state or the city of Seattle, even predating COVID, where the employer was not doing a good job reminding the employee that they had this benefit available. Plus, if the employee might qualify for FCRA, you need to tell them about that. And if they qualify for Washington State paid sick leave at the same time, you're going to need to explain that they have the choice between the two. So really, this is where training your managers and frankly, training your workforce about what questions to ask if an employee needs time off is going to be helpful and help you meet those compliance. But it sounds like you're already doing a great thing, Victoria, in trying to get the word out about what's available to folks, and that's going to really help there. What I'm more worried about when I say the mistake is the employee says, hey, my brother came down with COVID, I think I need to take some time off, and the employer says nothing about paid sick leave rights, right? That's rare, but it does happen, so be careful of that. Okay, I still get the question about informing the health department. Thought I'd let you know what my travels uncovered. There is still no affirmative duty to report to the health department for a single case. In case you're curious, it's the medical provider who's supposed to report that to the health department, and the health department handles the contact tracing. Now, there's an exception in King County. I looked in a couple counties last night. I apologize, I didn't have a chance to look in them all. So if you want us to check for your county, we certainly will. But King County has a food service workers special requirement that's newish. And that is if you have 2 or more cases in your workplace within a 14-day period, the employer must report to the King County Health Department within 24 hours. Now, I put on here, if that's not the rule for your county, it's probably a good idea to follow it. That's as much as I'm going to say for purposes of a webinar where you're not my client. Whether you choose to do that or not might have legal consequences, and it's probably something you want to talk to your lawyer about if you're going to choose to not report. And of course, there's public issues and other things by going forward. Most of the employers I work with err on the side of over-reporting because they care about workplace safety and that of their guests. I'm not saying that you don't if you choose not to do that. It's just something that you probably want to work on with your lawyer. And of course, we heard about all the contact tracing rules. Remember when everybody was going to have to basically keep a log of everybody's blood type, name, address, and where they've been in the last 2 weeks? We don't have to do that, but there is some information we have to have handy. So be ready in case the health department calls you. I mean, you can make sure that they're really from the health department and they're legit, but we do have an obligation to cooperate with those questions. Do you need to tell your guests or your customers or vendors or anybody who could have come in contact with the employee who has a confirmed diagnosis? Legally, there's no current duty to report. Whether you want to is a different question, but for purposes of the webinar, I'm telling you that there's not a legal duty to do so, but there certainly might be reasons that you do. I have many clients who just really feel that it's important to let guests know, and they've adopted the contact tracing rules for doing that, which we're going to talk about in a second here.
Got a question related to that. What specific information will the health department want from me in regards to contact tracing?
You know, I've never talked to the health department about it. I know generally what they're going to want to know is the employee and the close contact employees. They're going to ask for addresses and telephone numbers, because what the contact tracers do is they're basically trying to find out somebody who was ill and then figure out with whom that ill person may have come in contact with. So that's where, you know, you hear things about a cluster at a barbecue or a party. It's because the health department has actually figured out that these 10 people were together at this party and that's probably how they got sick. They're not going to go into health details or medical information about your employee. That would be privacy rights, but it's probably mostly going to be contact information, but they may want contact information for these close contact employees.
Great.
So this rule hasn't changed. Which other employees do I inform? And really what this question is, which other employees do I need to think about putting under quarantine? So my shorthand is close contact employees. The CDC uses the phrase people you come in close contact with, so we're going to adopt it. This rule is the same. Whoosh. Okay, so remember it's these three numbers, 6, 15, 48. So if I tell you I have a diagnosis of COVID-19, you're going to ask me which employees I came in contact with in the last 48 hours for 15 minutes or more, and we were within 6 feet of each other. That's the folks who kind of fall into that bubble of definition of close contact. And it's 48 hours of me first showing symptoms, so that can be a little bit tricky, right? I have the fever and trouble breathing, but I don't get my actual diagnosis till 2 or 3 days later. I've had this happen with clients. So when we're asking about the close contact employees, we've actually sent that employee home the first day they were sick. They've been out of the workplace for 3 days, but we have to go back and find out who they came in close contact with on day 1. The hyperlink for the 6/15/48 actually will take you to an article that my firm wrote about it that I think is a little bit more easily digestible. It also has the links to where the CDC guidelines are, and that you're absolutely welcome to read them. But this is what a close contact employee is. Oh, and by the way, remember I said the close contact employees is probably who the health department might ask you about. Wouldn't be surprised. Okay, so now that we've identified who's in that close contact circle, I'm going to call it, we need to decide how long they're going to be out depending on whether they're sick or not. So this is the symptomatic versus asymptomatic tree. Remember I said at the very beginning, that's what the CDC looks at. So the incubation period for COVID is still 1 to 14 days, they think, right? That's what it's been, and that hasn't changed, at least to date. So the health department here, I kind of like the way that King County phrased it, so that's what I decided to cut and paste for the slide, but the CDC says the same thing. Any staff that have been within this close contact should not go to work for 14 days and quarantine themselves. That's who we need to send out of the workplace. And hold on, I'm going to talk about leave in a second, I promise. And then when can they come back? Well, guess what? It's these same milestones if somebody's been sick that we had before. So 14 days is no symptoms. The milestones are if there's symptoms, which kind of makes sense. This person, you don't know if they might have it. This person, you do. So you're going to follow that different set of rules. So what leave exists? Well, I put some stars here because we're back to this problem with the Families First Coronavirus Emergency Leave, which is us just telling somebody to go home for 14 days is probably not going to qualify for the Families First leave. However, remember, if we get a doctor to confirm that the employee needs to stay out that long, then we suddenly have the information we need to have them qualify for the federal leave. And I never want you to discourage employees from reaching out to their healthcare provider. That's a good rule of thumb anyway. So that's why I have that star there. But let's say, oh, heaven forbid, we get a really big spike again and it's nearly impossible to get in touch with a healthcare provider. Well, you're probably going to be stuck with just offering the employee their Washington or Seattle paid sick leave, or maybe you have a combined or universal PTO policy. That's going to be available to them for this quarantine period, or the period during which they're out awaiting diagnosis. And don't forget, if they become ill, more than 3 days, so this is somebody who actually really gets full-blown COVID, then they're going to qualify for the protections of the regular FMLA. Regular FMLA not paid, though. Regular Washington PFML paid through the state. This isn't an unemployment situation. I've mentioned it before, but I made it a separate slide. Can you require a negative COVID-19 test before somebody comes back to work? So the CDC is saying they strongly discourage this. They say to follow the 14 days quarantine or the symptomatic strategy. But again, we're kind of stuck with this catch-22 because if somebody's going to qualify for Families First Coronavirus Response Leave, we need that advice from the healthcare provider. So maybe the negative COVID-19 test isn't the way to go here. But again, I've had some of my clients who get set up with a local healthcare provider and are able to get testing pretty quickly. So I'm unable to give you specific advice for you here. But if you wanted to require the test, you could, legally speaking. If you didn't want to require the test, you don't have to, legally speaking. Okay, I'm going to pause before we talk about travel. Any questions?
We have a few questions here. Going back to one of the first ones, is there a COVID handbook available that can be shared? I know that one of the questions from the employer said that they have a COVID-19 handbook that they distribute to their employees. Is there something that Fisher Phillips has, or the CDC provides, or Department of Health provides?
So I guess I would need to know what topics there are. I don't have a Fisher Phillips. We have a lot on our website of forms that are free. We don't have an all-in-one book that I can share. I will also say that there's a lot of free stuff out there. I know the association recognizes that getting it all together is almost what seems more overwhelming. I would say if you went through and printed everything of all the landing pages I've given you today, you're going to end up with a pretty good guideline. If you're looking for things more specific, like, for example, I think it needs to be updated, but my hospitality group has a multi-state, restaurant guide about who has to wear masks and whether guests have to wear masks and leave and things like that. There's some tools like that to help you through. So maybe Lex, whoever that was, can send you or me a note afterwards and let us know, what kinds of things that they're looking for, and I might be able to guide some resources.
Okay. I have a question from Wendy. Is there a template with questions we should be asking our employees when they arrive at work?
So I assume that's a question directed towards symptom screening. So if you want to do symptom screening, the answer is yes, but that's not something I can provide for free. That would be constitutes legal advice, and so it'd be something you need to engage me or other outside counsel to look at. If you go to the CDC, though, again, there's a business FAQ, and I'm happy to send that to Lex and you, that talks about what kinds of questions that you use. But I've certainly developed pre-shift symptom screening questionnaires for some of my clients, and they do use those. Where they can be helpful is then you can use them in conjunction with some FCRA forms. But usually those questions are, you're asking about the recognized COVID symptoms, including having somebody identify if they have a fever or you provide a thermometer for them, and including where they've traveled. So yeah, there is stuff like that available. It's just not something that you're going to find for free unless you want to create your own following the CDC.
And I have a question from Anne here. Is the COVID testing free to the individual? I have received bills from healthcare places.
No, COVID testing is not free unless you pay attention to when there's a free one. I'm smiling because we had a free one up where I live in Tukwila. My husband headed up because he's got a mother who's 82 years old, and he was just concerned because he'd been around her and got it done. But generally, it's something you're going to have to pay for, and particularly if the employer is requiring it, the rule of thumb is going to be that the employer needs to pay for it. And this is basically because there is no mandate that individuals get tested before they return to work. So just like we would pay for a pre-employment drug screening test, it's kind of the same sort of rationale here.
Okay.
So I wouldn't, yeah. So we'll certainly follow up on those other things and give some guidance there. Thanks for the questions. So let us go to these travel issues. I get this question all the time in two different extremes. One is my clients are trying to develop business travel policies to decide what they're going to do. Generally folks are trying to discourage business travel, but there are some things that need to take place in person, although I know Lex and I think that this platform works pretty well. The other extreme questions that I get is, I'm laughing, I've had some clients where they have a few employees who are very excited about all the discount air travel to Las Vegas and hotel room discounts, and are doing some travel out of state. I've even had a client where one of their employees' family was getting married in Phoenix, and so the employee was traveling to Arizona frequently, particularly in the peak of one of Arizona's outbreaks, and that was causing concern. So unfortunately, we don't have much other than guidance from the CDC about how to travel safe and what precautions to take. So these were all updated. I've given you the links here. You've got the general landing page, the precautions for travel, and the FAQs. If you have business travelers for your work, or if you even know employees are traveling, or even if you don't, this is another great time to communicate with your workforce about what the guidelines are about intrastate and interstate travel. So that's travel within the state of Washington or travel outside the state. The first question I get when this comes up is, well, can I just prohibit employees from traveling? So you certainly can prohibit employees from business travel because you're just not going to approve it and set it up. But can you prohibit employees from flying to Las Vegas to play in the blackjack tournament? So probably not, even in the state of Washington. Now, some states, like Colorado is one of them, actually, have specific prohibitions that would prevent an employer from banning off-duty lawful conduct. We're not quite that extreme. Isn't that funny that Washington doesn't have that yet, but we don't. However, we have some public policy considerations. So telling an employee that they can't go to Las Vegas is probably not a good idea for purposes of this webinar. However, you can require employees to tell you about past or future travel plans. And in fact, you should. You need to be able to evaluate that risk. So back to the question about the pre-shift screening questionnaire, some of my clients include a question on there about recent travel in the past 14 days, for example. And if you know an employee has traveled, you definitely at a minimum want to monitor them for symptoms. In fact, you can require that they self-monitor for symptoms and fill something out every day. Let's say you decide to not do a pre-symptom check questionnaire for everybody, but you could do it for the folks who have told you that they've been to Las Vegas or Arizona, or it used to be New York, or down to a Florida beach. What are the quarantine guidelines if somebody travels? Well, I said here, I sure wish somebody would give them to us, but we don't have really any clear direction. Now, I think part of this is that we've seen a lack of advice and cohesiveness at the federal level, so it's been left to the various states, and I think this is one of those things. So for Washington State, for example, we currently have no quarantine requirements upon travel to our state, which would also apply to somebody going out of state and coming back, but like Florida does. So if you were in Florida and you left Florida and you came back to Florida, you could actually require your employee to quarantine for the period that is currently under the travel guidelines. Washington doesn't have that, so we don't have that here that would kind of give us some helpful. We do have that the CDC says all travelers should avoid non-essential international travel. I think you could be a little bit more firm with your employees about that if somebody says they're, flying to, I don't know where, Morocco, France, Japan, China, anywhere. Perhaps that's something that you're going to discourage, although I'm not sure you can prevent it. So what do? Well, you're probably going to have to follow the symptomatic, asymptomatic guidelines. And as I've said here on the slide, though, the CDC isn't giving us much for somebody who's traveled and they're asymptomatic. They're just telling us the usual, that employees should maintain social distance of 6 feet or more. They should wear a mask. They should wash their hands. They shouldn't sneeze on people. It's really not helpful, so it's going to be up to you. I put a lot of questions with hotspot here because the CDC didn't really give us any different guidelines other than to say hotspots are more dangerous. All right, so what do you want to do is really what this is going to come down to, and what makes sense for your business. So we need to talk about leave and also requiring testing. So if an employee particularly says they've been off to their family's wedding in Arizona for several weeks now, could you require them to take a test before they come back to work? Yes, you could. You have that right. There's a couple things I want to point out, though. Remember, if they're just having a viral test, it's up to a 14-day incubation period. So having somebody test the day after they got back from Arizona, have them be clear, and have them come back to the workplace 3 days later actually isn't going to catch if they have the virus. That's number one. Harvard has a study out, if you Google it, you can find it, that says it probably takes 3 to 5 days typically for symptoms to start to show. So that would be 3 to 5 days from exposure. That's typical, but the incubation period is still up to 2 weeks. Then the next question I get is, well, what if I have that employee go do an antibody test? I should be able to know even more definitively if they've had it or not. Again, that isn't going to be an immediate answer. The CDC says it's 1 to 3 weeks to even start creating antibodies. And I've given you the page here that'll take you to that. The last point on this slide is whatever your rule is, it has to be the same for all employees. That's for lots of reasons. I don't want you to end up in a situation where you're only testing women and not men, or only testing people of color and not white your white employees. But the idea is too, it also is just fundamental fairness. So it should be any out-of-state travel, you're going to have this list of guidelines, and it's probably something you need to think about.
I have a question. I have a question related to travel from an anonymous user here. What if an employee was told by their healthcare provider to quarantine, but uses that time as vacation instead?
So I presume that the employer has allowed for paid leave or put in for FCRA leave or Washington State paid leave because of the healthcare provider recommendation. I think that I'm not going to give a definitive answer because this is getting into legal issues. Generally, I can tell you, though, here's what I spot. If you have evidence that the employee is doing something fraudulent, or if you have evidence, for example, that the employee was supposed to stay home and self-isolate, but I don't know, now they're playing soccer and going to family reunions and not wearing a mask and running around. Because Washington State doesn't have that off-duty conduct law, you may be looking at a situation where you could terminate somebody, but I am never going to give a recommendation about whether it's okay to terminate somebody in a webinar. There's so much more that I don't know. Plus, you want it to be attorney-client privileged, so that we all don't have to testify at the lawsuit. I know that you said anonymous, but that still could be a concern. So that one's really one to reach out to your lawyer about. Certainly, I'm not happy to hear that that could be a possibility, and people who abuse their leave rights is one of my pet peeves. All right, so let's say we have this employee who comes back from Arizona and we want to have them quarantined for 14 days. Again, you could require them to do that, but we're going to get into a situation where they might not get paid for that 2 weeks, depending on what you decide to do. So without a doctor's directive, they're not going to qualify for FCRA. We've talked about that multiple times today. Although we're going to encourage that employee to talk to their doctor, and maybe they'll end up with the directive so we could offer that leave. Somebody who's just quarantined because they came back from travel or you asked them to is also probably not eligible under Washington State paid sick leave, in the sense that you have to make it available to the employee. There's also no requirement that you have to make PTO or vacation available to the employee. But there's one but, and there's that I've said on the slide, and another but that I'm going to tell you. If you want to make employees' vacation available to them while they're in this quarantine period, you certainly could. Same with Washington State paid sick leave. Where you would get into trouble is if you thought you were going to be able to claim FCRA leave for that period, because you're probably not going to qualify for the tax credit. Now, the other but I have on here is something more subtle that you need to talk to your lawyer about, which is if you start to view somebody as disabled, even if they're not disabled, you can actually get a disability discrimination claim. That's going to be really fact dependent. But I dealt with this with the swine flu years ago. And we may actually be in a situation where your lawyer would recommend that you offer paid time off. So I know this feels like you're rewarding somebody who took a vacation that wasn't so sensible with another vacation. But in the end, you're trying to protect your workforce from getting sick. And so, maybe that's something that you choose to do. Okay, I'm going to pause here because we're going to get off travel. I want to talk about high-risk workers a little bit. Are there any more questions about travel?
Somewhat related. Susan has a poster with guidelines on when you can and can't work. The first example is that the employee has a household member who's diagnosed ill but aren't showing symptoms. The poster says the employee can work in that situation. As an employer, Susan has, in a restaurant, she's uncomfortable with this. What is your advice?
I don't know where that poster came from, so I can't really comment on it.
BFHD is, I've never heard of them, but.
I don't know. I can tell you that it may be out of date.
Okay.
So the CDC guidelines that we've talked about today have just been updated. If you go to, and it also depends on the county, so it may be a good idea to find out where that poster came from and talk about if it's up to date or not.
She said Benton Franklin Health District.
I don't know when Benton Franklin has updated that.
Yeah, so check on when that was updated, Susan.
Yeah. I think the first thing to start is to look at the CDC and then also call the health department. Okay. And look, just because it says may doesn't mean you have to. So particularly, I mean, I'm going to talk as a business owner. If I were a business owner and my head server came and told me that their sister had COVID, I would absolutely send them home to get a test. And I would tell them to call their doctor, and I would probably get their doctor to say that they should stay home and have a test. And if they didn't come back with symptoms, then they get to come back to work earlier. And you know, I've had directives where it's not necessarily 14 days, it's a shorter period, and you have a negative test. So you can reach out to not just the health department, but encourage the employee to get some medical advice there that might guide you through this. But yeah, the biggest thing is to check to see if that poster might be out of date. These things change every day. I know it's hard for everyone. Okay. We're going to talk about high-risk workers. I'm sure you all remember at the beginning that I said that there was a new guidance from the governor that got snuck in when he extended this high-risk worker proclamation. So remember, the governor's proclamation is that an employee who is at a high risk for COVID-19 has you have a duty to offer them feasible alternative work arrangements. It sort of feels like reasonable accommodations, but the phrase is different. So if somebody's an office worker, that's probably easier as opposed to somebody who's a chef in your kitchen, right? It's going to be hard to come up with a feasible alternative work arrangement for your chef. They probably can't do that from home. It's probably impossible to have them working alone outside of 6 feet from everybody else and to take some other precautions. So this law says that if you cannot provide a feasible alternative work arrangement for that employee, you must allow them to use at their election any Washington or city provided paid sick leave. That means, by provided, I mean we have that policy because the law says we have to. Or they can go on unemployment. And the state will basically put them in standby status, although everybody's still in standby status now, but they can collect unemployment benefits. Now, when this came out, I got a lot of questions, and me too, I wondered, well, wait a second, how are we going to verify that the employee is in high risk? I mean, if somebody is over 65, I can tell that, but I don't necessarily know if somebody has chronic obstructive pulmonary disease or diabetes. So here's what the governor's new order says. There are several categories based on some refinements from the CDC. The first one is you are at increased risk per CDC guidelines. I'm going to tell you here that it's best to just print this out for your COVID guide or have the website bookmarked. But this is things like somebody who has cancer, is immunocompromised, they had an organ transplant, and believe it or not, if somebody's obese, they fall in the increased risk category. They have a serious heart condition, sickle cell disease, or type 2 diabetes. All of those folks, we can't ask for a doctor's note. They just let us know that this is what they're suffering from. We have that dialogue about feasible alternative work arrangements, and we go on from there. However, if the employee wants to use paid sick leave, or for some reason, I don't know why we think they would qualify for FCRA, you're allowed to ask for the doctor's verification because those laws say that you can. So there's a crossover, just remember you got to follow the other law. Might be something you need to talk to a lawyer about. Then there's this next category of might be at increased risk. I had somebody say, now it sounds like everybody might be at increased risk. Well, what it is that the CDC and our state has recognized that there's some other diseases where it might be putting you at increased risk. But we really want to hear from the doctor here. So if somebody comes in and says they have asthma and they can't work anymore until the pandemic is over, you are allowed to ask for a doctor's note to verify that they are unable to work. In fact, I'm hoping that you're having a dialogue with the employee and you can encourage them to please have their medical provider share if there's any procedures or things that you can do at work to help them. Hypertension is another one of those that might be. So it is going to depend on what the employee's condition is. Pregnancy is another one in this might be at increased risk. So if an employee is telling you they're pregnant and they can't work anymore because of COVID, you are allowed to ask them to provide a medical note confirming that they're unable to come to work. So I actually view this as helpful because now there are instances where we can ask for information. Any questions about high-risk workers before I move to my last slide? No. Okay. We're almost there. The last question that continues to come up, in fact, it came up so much, the association was kind enough to ask me to help with the Q&A, is what do you do if a guest refuses to wear a mask? I'm not going to go through all of this today because I think that you can read this and get some information yourself. But I wanted to let you know that we did put something together. So it runs through everything, which is basically, regardless if somebody is asserting that they have a medical condition or not, you just need to be ready with some form of alternatives. So it might be hard for a spa treatment, but rescheduling somebody's service or providing an alternative treatment. If it's a restaurant, you would say that they could do curbside or takeout instead of dining there. That's pretty much going to help you with the potential legal claims under the Americans with Disabilities Act. But also go ahead and just read this. I think it'll give you more of the information and walk you through it. And then the association or I are available for questions. So I know I've only got 5 minutes left, but I am happy to take any other questions that you might have, or let me know if you have one and we can certainly get back to you later.
Okay, I've got a few questions coming up here. Let's start with Susan. What if you have an employee that you know is at high risk with a few factors, but you know they don't want to bring it up and want to work?
So I'm presuming, like, let's just say we have a 66-year-old person working for us and we know that they had a heart attack last year. I'm making up the hypothetical.
Sure.
Believe it or not, you actually don't have a duty to go tell them that they can't work. If you start sending them home because of that, you do run into a disability discrimination lawsuit. I mean, this one's a little bit more subtle in the practical answer for how to handle it. I mean, the legal answer is you don't have to tell them anything. The practical answer might be that you will go ahead and have that conversation there and ask them if they've reached out to their healthcare provider to find out if it is okay for them to come at work, and then you probably want to make a note of that.
Okay. Got another question here from Dan. With my business being temporarily closed due to COVID and my employees receiving unemployment benefits based on standby status, will my business's ESD experience rating be raised?
That is a technical ESD question that I cannot answer.
Yeah.
Sorry, I'm smiling because there are some things I don't know.
Okay. And we might have a future webinar to talk about ESD type topics. So Dan, stay tuned for that.
Yeah.
Another anonymous question. When your employer has you take a 20% pay cut, what is the law around this? When there have been, does there need to be an end date stated? Is there a form that has to be signed by both employee and employer?
Yeah, sure. I can talk about this a little bit. So if you're an at-will employee, or even if you have a contract, your pay is also at will. So if you have a contract, though, where you have a certain amount of pay, that's talking about renegotiating a contract, and you're probably going to need to execute that. So let's not talk about that situation. But But for a 20% pay cut, I get to tell you, I had to take a 20% pay cut with my firm because we had business concerns just like all of you. And so that was something that my firm did. They didn't have to get my permission. They did let me know. They explained to me what was going on, and we talked about the reasons. But in fact, the employer does not need to promise you how long that's going to be. They don't even need to tell you that you're going to have it back, generally speaking. Now, there may be some technical issues if you're a salaried employee and your salary is getting reduced. But generally, you know, the minimum salary test under federal law is less than 800, what is it, 784 now. So there's a lot of flexibility where you still remain an overtime exempt employee. I would say that it is a good practice to communicate with your employees the reasons for this, how long you anticipate to be going on, and what is happening. But there is no law that says you can't change an employee's pay unless we've got a contract or an enforceable written agreement. So the real answer to this might be a little bit more subtle than the general guidelines I gave you.
Okay. Those are the only open questions we have. Any final thoughts, Catherine?
Well, I know that all of this feels like we have to become healthcare providers now. And so I think that the guidance I want you to give is, yes, it feels that way. So reach out for help to get it right. I think the takeaway from me when I look at all this is that I want to be relying on information from a healthcare provider, even rather than trying to work through the CDC guidelines myself. And that's what I'm working with when I work with clients on this for exposure. I think when in doubt, err on the side of safety. I do think that that there are reasons to consider having a travel, automatic quarantine if you're dealing with those issues. I do think sometimes that, I guess if I had to give some general advice, is employers or managers look to a policy to do the management for them rather than having a conversation with the employee. One of those Vegas examples I gave, in fact, having a conversation with the employee about how they were putting their coworkers at danger and putting them at risk, ended up taking care of the problem. So, be open to that. Conversations and communication is what this is going to be all about. These are tough times, and everybody is faced with challenges, a lot of misinformation and too much information. So the association is a great resource. They can certainly point you to things. I am available during advisory network calls if you think it's something where you might need a lawyer as well, or hopefully you've got counsel that you work with. So with that, I think Lex just put up a poll, and we want to know your feedback. So please let us know how it went, and stay safe and healthy.
Great. And we will have the PowerPoint that Catherine went over available to you afterwards. And later today, we will have a replay of this webinar available probably by YouTube, and we'll get you the link out of those later today. Again, thank you, Catherine. As always, you did great work, and the members and the industry appreciates all that you do. And thank you. And for everybody else, have a great day and stay safe.